Thank you kindly, Mr. Chairman. Welcome to our witnesses. A couple months ago, I got a postcard in my mailbox, which let me know that 3 books that I've written over the course of my career had been used to train Anthropic's Claude AI large language models, and because of this, I was entitled to be part of the settlement in the Bartz versus Anthropic case. Now, this surprised me because, first of all, it reminded me that I used to write books. Now I just post 280 characters every day. But it also surprised me because I didn't know anything about the litigation, much less did I know anything about the fact that Anthropic had essentially swallowed up the contents of 3 of my books, apparently rejecting the relevance and the utility of several other books I'd written. But Anthropic had never called to ask me to use my books. But a judge found that Anthropic's ingestion and digestion of my books without payment was fair use. Claude AI may not be allowed to simply reprint my book and regurgitate it line for line and sell it, but it may profit off of my word choice, my cadence, my style, such as it is, my conceptualizations, and my research, among other attributes of my writing, for free. Now, if I finally get around to filling out the form, which means I have to finally get around to finding the postcard, I may get a de minimis check in the mail because the judge did find Anthropic had used pirated versions of the books that it used to train its large language model, and the parties, including apparently me, settled shortly after this holding. Now, we'd be cavalier to write these training episodes off as random or minor incidents. AI companies intentionally select works with which to train their large language models, often with zero intention of paying the creators any royalties for use of their creative intellectual labor. Bartz versus Anthropic is just one ominous decision floating in a sea of developing case law in this brave new world to engage in a fair use vernacular borrowing of H.G. Wells' famous work of science fiction. But it's illustrative of the proliferating tensions between existing law and social values that have materialized as we live through this time of astonishing technological transformation. The advent of the internet and the explosive emergence of AI have fundamentally changed the way that we interact with each other, the way we conduct business, the way we think about human thought, human feelings, and human work, and the way we create and consume books, songs, and other creative works. Now, I tend much more to the heady enthusiast side of such changes over the brooding Luddite side when it comes to technological innovation. But that's only because I have a profound faith in democracy, in our capacity to manage technological change when we put our minds to it. So now is the time to pose and grapple with urgent and searching questions about the moment. How do we integrate titanic new technological changes in a way that supports rather than undermines the basic needs and values of our society? We know from experience that innovations mean little if they are left to create inequality and domination, joblessness, and poverty. How do we prevent the concentration of power and wealth, but instead work to fairly distribute the benefits of new technology so they become part of our common life and inheritance? In this new era, we must ask ourselves what is fair and what is just and what will secure the greatest good to the greatest number of people. And that's what I hope we will be doing today. When the DMCA became governing copyright law nearly 30 years ago, dangerous products and merchandise that infringed on intellectual property rights overwhelmingly had to be bought in person. Movie and music pirates created physical copies of recordings and literally sold them on the street corners. Our laws did not contemplate the spread of streaming, where content piracy occurs on a daily basis all over the world, as far away as Vietnam and the Philippines, and the pirates can create a new infringing site the moment one gets taken down. Consumer products used to be bought almost exclusively in stores, with the occasional counterfeit handbag on the street. Today, harmful counterfeit products like exploding batteries, toxic baby cream, and asbestos-laden crayons can be bought, often, usually unwittingly, by consumers online, and they arrive at their doorsteps in a matter of hours. Even our music laws were designed for a world where listeners discovered music through their stereos, which is why we are left with laws that prevent performers from being paid when their music is played on the radio. These issues affect not just the 2 million employees of the movie industry or the nearly $12 billion in revenue from the music industry, but also the consumers who end up paying the cost of counterfeit goods that break or cause harm or just drive up the price of the real product. The laws on the books may no longer be fair for these affected industries, and they are almost certainly unfair to consumers. I understand there are many proposals out there with ideas for improving on the current situation. I'm a proud co-sponsor of one of them, the American Music Fairness Act, which would ensure that performers are paid when their music is actually played on the radio. In many ways, AI has supercharged problems that have been percolating since the advent of the internet. Generative AI models allow us to use the internet faster, more accurately, and beyond our individual technological capacities, but our laws have not kept pace with all the changes. Our intellectual property laws were created at a time when it was safe to presume that one must be human to have cognition and an intellect. Some would argue that's no longer the case. It's long past time we considered how to continue protecting the creative fields and address the ramifications of the proliferation of deepfakes, training AI models on copyrighted material, and other areas where AI may be unfair to both consumers and creators. I know some of my colleagues want to do away with the regulation of AI companies altogether, but we can protect content creators and help businesses thrive at the same time. We don't have to choose. Congress should help provide for the safe adoption of generative AI models that take into account the environmental, labor, and social consequences of such technology. And we should do so while allowing the states to experiment with different approaches. I'm dismayed by those who have caved to a small group of billionaires and now a trillionaire who own these AI models and have proposed broad preemption of state common law causes of action and state legislative decision-making with no federal regulation at all. There's no reason we should do away with common law tort claims that act as the basic national safety net for fairness. The National Institute of Science and Technology should absolutely be allowed to test frontier models. And if AI models are being built on the hard work of artists, writers, and inventors, we should be thinking long-term to ensure that there are more artists, writers, and inventors a generation from now creating material to sustainably train the next wave of generative innovation to come. The rational next step for this committee is to ask ourselves how we can map a path forward for all Americans to use technology while ensuring laws that protect consumers and creators, workers, and families. Well, thank you for that, Mr. Chairman. I'm going to have to get you a copy of some of my books.
I downloaded them already. What are you talking about?
Not pirated.
So, Professor Viswanathan, the Northern District Court in California held in Bartz versus Anthropic that the use of copyrighted works for AI training constitutes fair use. You just voiced your skepticism about thinking that as just training. But according to the court, Anthropic is permitted to purchase a copy of a book and then use that work to train the model on language, writing, and story. Do you agree with the court's conclusion? Is that the right analysis?
That's not constitutional. That's a leading question.
Yeah.
I think that courts are struggling. And they're struggling for the same reason we are. The court said, to be accurate, that it was transformative. But it's still a question about fair use. Y'all, for those of you who are not copyright people, I'm sorry for you, but there's still time, and I will help you through this, right? So you say, I say to you, you infringed. And you say, well, you're right, I did, but I did it for good reason. It's an affirmative defense. And it has 4 prongs to it. The biggest ones are, did you do something really important, transformative? Did you change it in some meaningful way that makes it important that we preserve that? And the 4th factor is, does it affect the market? And I want to point this out, actual or potential market, right? For the work, for the original work. The courts are confused and they're concerned because they see the effect on potential markets. At least the Bart's court does, right? What's the potential market? You could license that work otherwise.
All right, so are there
Right?
licensing regimes in copyright law that can serve as a model?
Absolutely there are. There are licensing regimes that exist right now. You just asked someone a couple moments ago, how are movies made? They license and cross-license all the time. That's how movies get made. When you embed a piece of song into a movie, you license it, you cross-license it. So there are regimes that exist, and fair use is not an open and shut case. There's over 100 cases that are pending right now.
All right, so let me just ask you, are we going to be able to get to the solution within the existing contours of copyright law, or do we need to legislate to address the brave new world we're in?
It's hard because we're at a moment right now where we want to go with a light hand because we don't want to hamper innovation. We'd like to encourage licensing regimes. The thing I'm concerned about, Mr. Raskin, is the small creator who can't go up against the big tech company and say, help me here. There are also, by the way, schemes to help pay small creators. We have BMI and ASCAP standing as examples of collective rights organizations that clear rights for people so that they can get their royalties. So what exists right now? There's a lot that exists right now that we need to tap into.
Okay, thank you. Mr. Aston, I know that digital replicas are a big issue for SAG-AFTRA. You negotiated hundreds of pages of a 4-year deal with the Motion Picture Association that would prevent studios from creating fake actors, as I understand it, absent some compelling reason for doing so, or replicating real ones, and that seems to be more categorical. You can't do that. To get out of using living, breathing individuals on screen. Could you explain why collective bargaining agreements with provisions like those are necessary, and then answer whether they're sufficient to protect creators from individuals using AI to replicate name, image, likeness, voice, intonation, and so on?
Yeah, absolutely. So they're absolutely necessary because the relationship between workers and their bosses is often fraught with being taken advantage of. And so we're very grateful that the companies in the previous cycle, when we had our big strike, but in this cycle, were willing to work with us to try and figure out how to manage the fairness when it comes to digital replication and what you were talking about with synthetics. And you know, when it comes to digital replication, we're able in bargaining to achieve an understanding about how much we should be compensated.
Is that sufficient in your field? Does it cover all of the people in the workforce?
Well, our collective bargaining agreement is our labor. So no, I mean, each different union, the writers, the directors, the IATSE, everybody has to make their own deals.
But is everybody represented such that they could come up with a similar agreement?
Everybody has to try to accomplish what we did first, which is to get meaningful artificial intelligence protections language in our bargaining, and we are. We're respected. SAG-AFTRA and our policy writers, our contract negotiating team is really been in the vanguard in this. But to me, for this moment, the important thing is it's only good for contracts that we are working with, that, you know, people who are signatory to our union. This No Fakes Act and the digital replication we're talking about exists everywhere else. And that's where nobody other than this body can offer the protections that we require, which is why we really appreciate you all working so hard on the piracy, but on this No Fakes Act.
Thank you. Mr. Chairman, you'll back.